This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Arizona State University has sued Facebook and Instagram for trademark and contributory infringement over this COVID-19 hoax account. And the defendant's answer is so offensive, it has had to be redacted. Let's take a look at what's going on here. This action involves the unauthorized use of plaintiffs' ASU and Arizona State University federally registered trademarks, as well as school colors and trade dress by an Instagram account, ASU_COVID.parties, to promote the so-called Hoax 19 COVID party, claiming that COVID-19 is a big fat hoax and spreading dangerous misinformation about COVID-19 just as students are returning to ASU's campuses to begin classes on August 20th, 2020. Plaintiff, Arizona Board of Regents, brings this action to stop this unauthorized use of the ASU marks and trade dress and shut down the account. This unauthorized use of trademarks and trade dress harms ASU, but if not enjoined, is also likely to endanger the health of the university community. There is already evidence of at least one instance of actual confusion regarding ASU's affiliation with this account, with an alumnus threatening to cut off all support for ASU because of the apparent misperception that this account and its messaging comes from or has been sanctioned by ASU. ASU also seeks relief against Facebook as a contributory infringer. That's a really high standard. Let's see if they even get close to meeting that. Before filing this action, ASU first filed a trademark infringement report with Instagram, asking that Instagram remove or alter the offending account, but Instagram has refused to do so, despite actual knowledge of the infringement, which they're saying now you have knowledge, and the ability to control and monitor the ASU_COVID.parties account on its platform. And contrary to its own terms and policies and guidelines, Facebook continues to provide its Instagram service to the account, which in turn provides the means of infringement. Further worsening this situation, the initial investigation indicates that the parties behind this account may be located in Russia and are using the account to sow confusion and conflict and interfere with the health of the Arizona State University community by trying to worsen the pandemic here. This lawsuit is also necessary in part to discover the true identity of the parties behind this account. Because of the serious public health issues involved here, ASU is seeking expedited discovery as well as a temporary restraining order, preliminary injunction, and permanent injunction, etc., etc., etc. An expedited discovery means they're seeking the identity of the alleged infringer or owner of the ASU_COVID.parties account, and if they get it, then maybe they'll be able to pursue some kind of action against them. This is very reminiscent of the Watchtower Bible and Tract Society case that we sort of went over. There was a subpoena to Reddit and then a subpoena to YouTube, so we have videos about that. Go check them out. And I'm going to bring this all back around at the end because I think this has something to do with that. We'll see. So back to the complaint here. Founded in 1885, ASU became known as Arizona State University in 1958 and has operated under their trademarks ever since. They own numerous trademarks: ASU, Arizona State University, Arizona State, and they are registered for various categories of goods and services, as you do. ASU invests substantial sums annually to advertise and promote its educational programs, services, athletic programs, and sponsored events in a wide variety of media, including Instagram and other social media, to students, prospective students, alumni, and the general public, all of which results in the wide and extensive exposure of the ASU marks and the maroon and gold trade dress to the public in direct association with the university. ASU has an official Instagram account with the username Arizona State University, all run together, that also prominently features their marks, etc. These marks have become famous and well-known and well-regarded. They're setting that up that it can't be, the mark can't be challenged. On or about July 19th, 2020, defendant John Doe, whose true identity and location are currently unknown, created an Instagram account with the username ASU_COVID.parties and posted the following message: "No more social distancing, no more masks, it is time to party!" In addition to using the ASU mark as the first part of the account username, The John Doe defendant included the Arizona State University mark immediately below the username on the post, an ASU logo within the body of the message, and formatted the post in ASU's maroon and gold color trade dress. As posted, the message falsely appears to originate from ASU or an account associated with ASU. As shown below, the username and account profile misleadingly suggests that the account is associated with ASU. COVID-19 parties because they're during this pandemic era, not a contest to catch COVID, throwing huge parties at ASU. Follow before we go private. The profile uses the heading ASU coronavirus parties and categorizes itself as an event planner throwing huge parties at ASU. On or about July 20th, 2020, the account began promoting our first party, which it named Hoax 19, as depicted below. Our first party will be called Hoax 19 because this idea that COVID is only rampant in America compared to other countries is a hoax. Come to Hoax 19, posting Addy soon. The following day, July 21st, 2020, ASU_COVID.party's account posted another message claiming COVID-19 is a fat hoax. We will party! We do not care what you snowflakes say! COVID-19 is a fat hoax! Thereafter, ASU_COVID.parties posted another message, again including the Arizona State University mark immediately below the username and claiming that we have partnered with an Israeli company to distribute hydroxychloroquine. All profits of the party will go to helping people in other countries get hydrochloroquine to treat COVID-19. A true and correct copy of this post, which indicates the commercial nature of the advertised Hoax 19 party, is displayed below. Other posts by ASU_COVID.parties encourage against wearing masks, which directly contradicts and undermines and interferes with the actual health-related message consistent with the local law that mandates wearing of masks at this time, and that ASU is attempting to provide its students and the community. Reminder, no masks allowed at parties for security reasons. We have received several threats. If you wear a mask, you will be removed. Masks and restrictions don't work. News Island has had cases for weeks without knowing it. The unauthorized use of the ASU marks and trade dress in connection with the ASU_COVID.party's username and posts are likely to cause confusion as to whether ASU is affiliated with, endorses, and or sponsors this Instagram account, its messaging that could result in dangerous public health consequences if followed by others, and the Hoax 19 COVID party that is being promoted through this account. In fact, on July 24th, 2020, the individual owner of the Twitter account, teachor, with a 0, claimed he would be stopping his alumni membership because ASU having COVID parties and claiming it's a hoax. So this post from teacher with a 0, ASU having COVID parties and claiming it's a hoax. I am stopping my alumni meebies hip and removing my alumni sticker from my car and sending back my ASU alumni license plate. I am embarrassed to be associated with thus ignorant behavior. I question whether that's a legit account, or maybe ASU is claiming that people who can't spell are graduates of their programs and donors to their university. I don't know. I'm a little confused. The account has posted objectively false statements and information about ASU, including, for example, the following post in which it claims that the account owner has won the battle in court and that ASU has been ordered to pay its legal fees plus $500,000 in damages. Good news! We won the battle in court and we're back. We want to thank everyone who supported us and all of the ASU students and alumni who donated to our legal defense fund, with a C. Because of you, ASU now not only has to cover our legal fees, but they also have to pay out $500,000 to cover our sponsorship losses. We expect to have the money in 2 weeks. See you all back on campus and let's party! No such lawsuit or claim or judgment for damages exists. If that were not enough, in several posts, the owner of this account portrays ASU and its leadership as Nazis, referring to ASU's President Crow as Führer Crow, and comparing ASU's mask requirement to forcing Jews to wear a yellow Star of David. In offering the Instagram service, Facebook has implemented a robust set of terms of use, policies, and community guidelines governing the use of that service, including ones that are directly related to the COVID pandemic. And you can see those here. These are not my highlights. I guess they're highlighting out the fact that we want to make sure our community guidelines protect people from harmful content, etc., etc. Sort of subjective there. On August 12th, 2020, undersigned counsel on behalf of ASU submitted a trademark infringement report identifying the federally registered ASU marks as being infringed by the ASU_COVID.parties account. On August 14th, 2020, Instagram responded that the reported party appears to be using your trademark to refer to or comment on your goods or services, and that it would not be taking any action regarding this account. Now, wait a second. What does it sound like? They're using the trademark to refer to or comment on your goods and services. That sounds an awful lot like a fair use parody. As shown in paragraphs above, Instagram's response mischaracterized the account's use of the ASU marks because neither the account profile nor any of the specifically referenced posts refer to or comment on any of ASU's goods or services. Arguable, but I can also see the other side. We'll see what the response from the defendant is in just a moment. Instagram responded on August 17th that it would not act on the report to remove or modify any aspect of the ASU_COVID.parties account. Instead, Facebook continues to provide its Instagram service to the ASU_COVID.parties account, which account is being used to infringe ASU's rights and in violation of the Instagram terms of use and community guidelines. As such, Facebook is contributing to the ongoing infringement being committed by the account. Now, contributory infringement does require either willful blindness, actual knowledge, or a should-have-known standard, so just ask yourself whether Facebook and Instagram are really on notice that this is clearly infringement and therefore Facebook is supporting it to the point that they're liable. I have my doubts. But real quick, they assert trademark infringement against the account, false designation of origin in advertising, which is kind of like, it's kind of part of trademark. It is part of trademark. And contributory infringement as to Facebook, and trademark dilution and unfair competition from the account. And then what we get is an answer from the John Doe defendant that is so offensive to the court that the court later strikes the entire answer from the record. I was able to obtain the answer before it was sealed from the record, and we redacted out the most offensive words so that it would be compatible with a reading on YouTube, and here is that document. This is John Doe's answer and objection. They admit some allegations, they deny some allegations, not so worried about that. Defendant admits that wearing masks is a total effing joke, fake news, and that mask restrictions do not work, as per Governor Ducey, as evidenced by the July 13th, 2020 Arizona Republic news story. Photo shows Ducey at party with no masks and no social distancing. Governor's office claims smear attack, but denies the remaining allegations. Defendant admits to having engaged in a series of offensive statements about ASU, but denies the remaining allegations, so suck it. If you're too effing stupid to recognize parody and hyperbole, which is protected by the First Amendment, that's your effing problem, and maybe you need to hire better lawyers than the dumbasses at Backle Law Group, which I heard is run by a bunch of drug-addled QAnon-loving people who do inappropriate things with children, more interested in sucking the taxpayers dry with frivolous slap litigation than in doing any actual legal work. The First Amendment allows me to be as offensive as I want to be, so suck it. Speech is powerful. It can stir people to action, move them to tears of both joy and sorrow, and as it did here, inflict great pain. On the facts before us, we cannot react to that pain by punishing the speaker. As a nation, we have chosen a different course, to protect even hurtful speech on public issues to ensure that we do not stifle public debate. Defendant is not liable to plaintiff because plaintiff and its organization is a public figure, public official, and fails to plead actual malice with regards to any alleged defamatory statements. Okay, I don't remember there being a count in there for defamation. Okay. Defendant is not liable to plaintiff because he is engaging in non-commercial political speech regarding public officials, public entities involved in matters of public concern, therefore enjoying the fullest of First Amendment protections. Okay, could be that this is in furtherance of the trademark parody. Defendant is not liable to plaintiff because defendant was entirely engaged in protected First Amendment activities, and the Instagram account in question is clearly a parody engaged in rude, offensive, and hyperbolic behaviors. Only a fundamentally stupid person who is way beyond retarded would ever think that this was legitimate ASU account posting legitimate ASU statements and information. The constitutional principle overarching in this case, which plaintiff either fails to understand or refuses to acknowledge, is that the First Amendment protects speech intended to cause embarrassment, insult, and outrage. Citizens must tolerate insulting and even outrageous speech in order to provide adequate breathing space to the freedoms protected by the First Amendment. See the Hustler Magazine Inc. v. Falwell case from the Supreme Court in 1988, noting the court's long-standing refusal to allow damages because speech may have an adverse emotional impact. The First Amendment may indeed serve its high purpose when it induces a condition of unrest or even stirs people to anger. Defendant is not liable to plaintiff here because plaintiff, ASU's president, Michael Crow, really is a Nazi. Plaintiff claims that these false and offensive posts are calculated to injure ASU's reputation and the goodwill associated with the famous ASU marks. But defendant is entitled to hold and to caustically express his opinion that Führer Crow is a person with extreme racist or authoritarian views, or a person who seeks to impose his views on others in a very autocratic or inflexible way, a common meaning of the word Nazi in wide usage. Particularly apropos given the facts of the instant case is this: we cannot curtail a speaker's First Amendment protection on the grounds that an otherwise permissible message might touch a nerve with an easily agitated audience. For those of you in Rio Linda, the internet is a vast and often unpleasant place. Those who step into the public limelight, even temporarily, must face the hazard that sometimes comes with it. Should they find a commentator's discussion of their foray into public life unsavory, they cannot easily cry foul. Führer Crow voluntarily stepped into the limelight. Doing so made him the fair subject of criticism. Crow can always resign and go back to chicken farming or whatever it is that Nazis do when they are not busy plotting a final solution while vacationing at Wannsee. With regards to the claims involving trademark infringement, false designation of origin, false advertising, trademark dilution, and unfair competition, defendant is not liable to plaintiff because defendant is engaged in fair use and fair comment as well as non-commercial political speech. As the court knows in Lentz v. Universal Music Corp., a copyright case, the United States Court of Appeals for the Ninth Circuit has held that copyright owners must consider fair use in good faith before issuing a takedown notice for content posted on the internet. Copyrighted content posted on the internet. Lentz argued that Universal was issuing takedown notices, copyright takedown notices, in bad faith as they attempted to remove all Prince-related content rather than considering whether each posting violated copyright and in particular was a non-infringing fair use. Importantly, the court viewed fair use not as a valid excuse to otherwise infringing conduct, but rather as not infringement in the first place. It stands to reason that the principles expressed in Lentz would also apply to the claims made in this case. Okay, they're making an analogy. I'll forgive that, sure. Defendant Facebook is not liable to plaintiff due to the immunities provided by the Communications Decency Act. This law is so well settled that it is incomprehensible that plaintiff's attorney would even bother to try to sue Facebook for contributory infringement. This claim shows beyond a shadow of a doubt that Glenn Bacall and Sean Garrison are a couple of thieving morons. Further, plaintiff has no legal basis or standing for suing Facebook over alleged violations of their terms of service. You know who doesn't have any legal standing to make those arguments is John Doe, who isn't representing Facebook or Instagram. Sorry. Glenn S. Bacall and Sean Garrison are a couple of corrupt and very stupid lawyers who are just trying to scam the taxpayers of Arizona by grandstanding with this nonsense lawsuit so as to get publicity for themselves and their really shitty law firm, while at the same time driving up legal fees via this obvious slap litigation. This lawsuit is complete BS, to use a legal term. There can be little doubt that the First Amendment protects against compelled identification of anonymous speakers. See Watchtower Bible and Tract Society of New York versus Village of Stratton and Buckley versus American Constitutional Law Foundation. Quote, an author is generally free to decide whether or not to disclose his or her true identity. An author's decision to remain anonymous, like other decisions concerning omissions or additions to the content of a publication, is an aspect of the freedom of speech protected by the First Amendment. Under our Constitution, anonymous pamphleteering is not a pernicious, fraudulent practice, but an honorable tradition of advocacy and dissent. Thus, any attempt by plaintiff or this court to disclose the identity of the individuals behind this anonymous Instagram account would irreversibly amputate those authors' First Amendment rights. It is also well settled that anonymous speech on the internet is afforded the same protections as anonymous pamphleteering, and since a court order constitutes state action, compelling John Doe's destruction of anonymity, either her or his own or someone else's, is subject to constitutional limitations. And beyond that, the restriction must be narrowly tailored to serve that compelling interest. That's the strict scrutiny standard that should apply to free speech violations. Publicity is justly commended as a remedy for social and industrial diseases. Sunlight is said to be the best of disinfectants, electric light the most efficient policeman. Should the court desire a hearing on this matter, John Doe asks that it be done in a manner so as to preserve her or his anonymity, with the understanding that it would be totally impossible for him or her to physically come to the courthouse and argue this matter, which would then result in the exposure of the very things he wishes to keep anonymous and would defeat the purposes of this motion and these fundamental constitutional protections. Not to mention the fact that he is now prohibited from even entering the courthouse there on account of the fake Chinese virus. Documents may be served via email. Respectfully submitted August 24th, 2020, John Jane Doe. And there's one mistake. There's one very critical mistake. It's a bit of a tell. If you've played poker, you know what a tell is. When you accidentally tell your opponent something that's going on, there is a certificate of service here. I certify that on August 24th, 2020, a copy of this document was delivered to the U.S. District Court's clerk, office by courier, which would automatically serve a notice of electronic filing on the plaintiff, Watchtower Organization. I'm guessing that someone copy-pasted something from a Watchtower case and either just the certificate of service or maybe the whole thing, and then modified it as necessary, which is not a bad way to go. Like many attorneys will go and find the documents that they need from other cases, and then they will tailor them to the one case. And sometimes wholesale copying and pasting does happen. It's generally frowned upon to plagiarize your other attorneys or competitors or co-counsel or opposing, other counselors' work wholesale, but it's not necessarily illegal. This is more or less functional speech. It's legally operative speech, so I'm not entirely sure that you get a copyright on a legal argument or something like that. I'm pretty sure that you don't. So you can probably go copy wholesale people's legal documents. What you can't do is copy their legal documents and then sell them yourself or something. I don't think that's legal. There's going to be a distinction there that makes a big difference. So then, the judge is so offended by that the judge orders the entire answer to be stricken from the record. For the following reasons, Doe's answer will be stricken, Doe's motion to allow electronic filing will be denied without prejudice, and Doe will be ordered to refile an appropriate answer. In addition, if Doe wishes to proceed under a pseudonym, he must file a reasoned motion for permission to do so. Doe's answer is filled with obscenities, inflammatory language, and insults directed towards the Arizona Board of Regents and its counsel. This is unacceptable. All persons involved in the judicial process, judges, litigants, witnesses, and court officers, owe a duty of courtesy to all other participants. It should go without saying that no participant in a judicial proceeding may address another participant with profanity-laced vitriol. For these reasons, Doe's answer will be stricken. Doe must, by September 4th, 2020, file an amended answer sans profanity and ad hominem attacks. Doe filed his answer under a pseudonym and, citing First Amendment concerns, indicated that he intends to continue litigating under a pseudonym. The use of fictitious names runs afoul of the public's common law right of access to judicial proceedings. Thus, litigation under a pseudonym is only allowed in a special circumstance, that is, the unusual case when non-disclosure of the party's identity is necessary to protect a person from harassment, injury, ridicule, or personal embarrassment. This creates a high bar for proceeding under a pseudonym. Doe cited the First Amendment as the basis for his desire to litigate anonymously. Although First Amendment concerns may contribute to a party's need to proceed under a pseudonym, they are only one factor among many, and a party still must demonstrate those concerns outweigh the public's interest and the prejudice to another party. Additionally, Doe's status as a defendant may further complicate the analysis. For these reasons, Doe's passing reference to the First Amendment in his now stricken answer is insufficient to overcome the presumption against anonymity in court proceedings. If Doe wishes to maintain anonymity in this action, he must file a well-reasoned motion to proceed anonymously. Any such motion must be filed before or contemporaneously with Doe's amended answer if he wishes to file that pleading anonymously. Doe has also motioned to allow electronic filing. Doe's participation in this litigation thus far has not inspired confidence in his ability to comport himself appropriately. Accordingly, that motion will be denied without prejudice. And that's Dominic W. Lanza, United States District Judge. But there's one more step to this. It seems that the temporary restraining order that ASU is asking for doesn't need to be filed because Facebook and Instagram finally caved and disabled the ASU_COVID.parties and ASU_COVID.parties2 accounts from Instagram. So based on further representations that Facebook has perma-banned this user and will disable future accounts in an attempt to circumvent its policies, etc., the immediate relief sought by ASU through a motion for temporary restraining order has been achieved. So ASU now gets to decide whether they want to pursue the rest of the case at all, because it sounds like Facebook and Instagram finally caved and took down the accounts. So that might be the end of the great trademark parody that is the ASU_COVID.parties account that I've just gotten good at saying. It's sad. Either way, trademark parody is a thing. That might not be trademark parody. Trademark parody usually has to be a parody of the thing. So a parody of Arizona State University, a parody. So the argument on the defendant's side would be that they've created this account to parodize and highlight and satirize the attitude that ASU and its Board of Regents and its leaders have had towards the COVID-19 pandemic. There has been some controversy in Arizona where I believe Arizona was late to the party, maybe. They were late to the party to protect people from the pandemic. And I think for a little while there was a governor that, I guess it was the governor they referred to here, that didn't want to wear masks and didn't think that masks were necessary and maybe even thought the whole thing was a hoax, kind of like the president said back in February. I think that it does smack of some kind of parody, and there would need to be a deeper analysis by a court as to whether this really reaches a level of parody that is protected and is not trademark infringement. Of course, ASU feels like, hey, people are confused about whether these terrible messages that are opposite and contrary to what ASU is actually doing, that these messages might be construed as coming from ASU. And of course, a trademark is a source identifier. So if you're putting the trademark on there and saying, you know, this is from ASU, that certainly is what gets the ire of trademark attorneys who are trying to protect ASU from misinformation and all that. So I understand both sides of this one. I think it's a really great case. What do you think? Do you think this was trademark parody, or do you think this was an illegal use of the trademark and parody is something more than what we saw here? Let me know in the comments below. That's today's show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube, Floatplane, and Twitch. Thank you very much to our supporters on patreon.com/ljfrench and sponsors.com/law for your monthly financial contributions. You make this channel possible. Thank you very much to the August $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Benjamin Hitov, Steven, Blackleaf, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, Engi, Brandyn, Abel, Torpidon, and Creative Corruptions. And thank you to the $5 plus supporters. All of the supporters are scrolling on the LED panel behind me and in the description of the videos below. We love you all. I will see you in the videos that drop. Have a great one. Bye.
I am running for you. I am running for you. I am running for you. If it gets too dark, I'll be alive. light.
Should have like, what's his name? Andy Buckley and the Suck It from The Office.
I was just thinking about that too.